Good morning, good evening, good afternoon, whenever and wherever you are listening to us. Hello, my name is Anita, and today I will just introduce the topic of the webinar from the Legal Insights for Modern Leaders by GESSEL and Strong Women in IT. And today's topic is super important nowadays. And it is entitled Reclassification of B2B Contracts into Employment Contracts, Risks, Myths, and How to Manage the Transition. And the session will be hosted by Dominika Ramirez-Volkiewicz, tax partner at GESSEL Attorney at Law, with her excellent industry experts. One of them will be Jona Krusiu, supervisory board member at Signity and finance director CEE at Total Specific Solution, and Piotr Michalczuk, executive partner at Talent Factor. So without further ado, Dominika, the stage is yours. I hope you have energy, because I believe I saw the presentation and it's great. So finger crossed, and you can start.
Thank you, Anita. Good afternoon, everyone. Welcome. Thank you for joining us today. My name is Dominika Ramirez-Volkiewicz, and I'm glad to be host of this webinar for today. We discussed today about reclassification of B2B contracts into employment contracts, and probably, as many of you know, this type of contract, B2B contracts, were dominant in Polish market for many years. And now, because of changes in legislation, this and also approach of tax authorities, this risk is of reclassification is real, and we need to focus how to secure your companies and if there are any alternatives to B2B contracts. We can start. Okay, so next slide, Justyna. What is the agenda for today? We have three parts. First part is B2B reclassification, and I will present some facts and some fiction about this reclassification. In the second part, I will present some alternatives to B2B, and if they are realistic in the IT industry or not really. And the last part will be expert discussion. My guests today is Joanna and Piotr, and we will discuss about risks, opportunities, and how B2B contracts exist in foreign markets also. What is fact versus myth in IT, and how authorities assess the realities of cooperation? This distinction is between form and substance is really important because authorities, tax authorities, social security authorities, or national labor inspectorate will focus on the reality, on the substance, and not on the contract itself. So let's look at the reclassification, what reclassification means in the business practice. So reclassification, in other words, reclassification means that civil law contract, like B2B contract, in practice is treated as an employment relationship with all obligation of the company as an employer. So with payment of taxes, payment of social security contributions, it's also related with some business risks, etc. Operational reality matters more than naming the contract. So I mean, about operational reality, I think about the way how the work is done by the B2B contractor. If it's in the company's premises, for example, if this contractor has paid leave or paid sick leave, or who directs the work, if other colleagues from the office, from the work, are employed under employment contract and they do the same job, the same task as the contractor. So these are many factors which should be taken into account. And the impact areas are, of course, labor law, social security contributions, because in case of reclassification, the employer, the company should pay social and health security contributions. The tax will be higher, and the business risk will be, in this case, also could appear. Next slide, please. Yes. And what is the fiction and what are the facts about, in IT sector, of course, about B2B contracts? As you know, why IT companies cooperate under B2B contracts? Because many employees, many people, many contractors would like to enter into B2B contract because it's flexible and it's tax efficient. B2B contractor can pay less taxes and get more money on their bank accounts. About the fiction, having sole proprietorship and issuing invoices makes B2B safe by itself. It's not true, because the substance is really important, and what authorities do. So it's verification of the reality of the operations day to day, of the substance, and if both parties want B2B, the risk disappears. It's also fiction, because the authorities are entitled to reclassify the B2B contract into employment contracts. And the facts are that authorities look at the actual organization of work and dependence on the client. And the biggest risk is of course the gap between the contract and day-to-day practice. For example, if the agreement is well prepared, for example, however, the practice looks differently than contract, so it's possible that authorities will reclassify such contract into employment contract. And what should be taken into account? It's, of course, direction, control, time. So, for example, the fixed hours of work from 9 a.m. to 5 p.m., place of work, the office, fixed hours, that contractor, for example, cannot work for the competitor. It's also the factor which could impact on the reclassification. And when a risk increases, when the cooperation looks like regular job within the company's structure, under, for example, the manager or team leader control, of course, the other factor which could increase the risk is long-term contract. If somebody works for one company under B2B contract for more than a few years, so in my opinion, the risk increases. And also a mismatch between contract and delivery could increase the risk. Next slide. And why this discussion appears about reclassification of the contract? Because the B2B contracts exist on the Polish market from many, many years. Because of the reform of the State Labor Inspectorate Act, that this institution, this National Labor Inspectorate, I will call it PIP, they have other possibility to reclassify this relationship if, in opinion of this labor inspectorate, this relationship, B2B relationship, meets all the criteria of the employment. This institution, labor inspectorate, they issue some proposition of questions which or issues which will be verified during this control of the state labor inspectorate. And there are many questions regarding some factors of cooperation, regarding place, directions, structure, paid leave, etc. And this reform strengthens the labor inspectorate's tool against replacing employment with civil law contracts. And this inspectorate may confirm that an employment relationship, because they will be entitled to issue a decision about this reclassification. Of course, the parties of the contract can appeal from this decision. However, it also will take time by the courts to issue a verdict on this. And as a rule, the effects of such decision of labor inspectorate will apply from the decision date. So not retroactive approach, but prospective approach. However, I will bring your attention to the fact that it will only signify that this is decision of the state labor inspectorate. However, the Polish Social Security Inspectorate or tax authorities may verify the previous years of contracts. This is related with the risk on the side of employer, because please remember that in Poland, the employer is responsible for unpaid taxes by the employee and by social security contribution, and employee is not responsible for this. During this during this procedure made by a Polish labor inspectorate, this entity will allow both parties, a company and its contractor, to present their position, to include some explanations, evidence, description of the cooperation model. And the inspectorate may issue before the decision a remediation order, and the parties can agree with this remediation order and to sign or include this employment contract, non-B2B contract. But in case of non-compliance with this remediation order, it can lead to a decision confirming the existence of an employment relationship. And once reclassified, the entity becomes an employer in Poland and must operate payroll, withholding tax, remit personal income tax, pay social security contributions, etc. And next slide, please. And this was I described some obligations or some risks for Polish entities. However, in my opinion, some consequences might appear also for foreign groups, because we know that in IT sector, many Polish freelancers or many Polish IT specialists work for foreign entities, for foreign groups. And in such case, if it appears that some B2B contract can be reclassified as an employment contract, so the consequences will be also on the side of foreign entity, foreign employer. And this might be related with cross-border risks such as permanent establishment in Poland, withholding tax to be paid, social security contributions. However, in my opinion, at the first stage, the Polish authorities will focus on the Polish-based relationships that rather foreign and Polish contractor relationship. Next slide. And this will be part second. So if they are realistic alternatives to B2B contracts in the IT industry. And further, in our discussion with the experts, I think we will focus more on this topic. However, I would like to take your attention to the fact that if you have not B2B but employment contracts, so it also could be beneficial for the IT companies. Next slide, please. Because in case of employment contract, there are some opportunities to IT companies because they could apply tax reliefs. I mean, IP box tax reliefs, R&D tax reliefs, and in case of R&D tax reliefs, employment remuneration resulting from employment contracts, together with social security contributions, are classified as qualified costs for R&D tax relief. And it means that at the end, the employer could treat remuneration of such IT specialist like tax deductible cost 3 times. So not only at once, but 3 times in case of R&D tax relief. Weaknesses of this solution, of course, higher costs, impact on pay structures, and lower flexibility. And threats, so talent loss to B2B because many IT specialists would like to be employed under B2B contracts, and pressure on project margins because of higher costs. Other alternative is refined B2B. However, please remember not only contract, not only wording of the contract, but reality matters the most. I think, next slide, Justyna, please. Because in a minute we will discuss with Joanna and Piotr about the real risks and opportunities for IT sector. But before that, I would like to invite you to limited consultation for webinar participants. And for the first 5 webinar participants, we would like to offer 2-hour consultation dedicated to reclassification of B2B, how to prepare for potential control. So Joanna, Piotr, please join us.
Hello.
Hello.
Nice to see you.
Piotr is joining us, so maybe Joanna, first question to you. How do you assess the scale of the risk of this reclassification of B2B contracts into employment contracts for IT sector in general, in Poland and for foreign entities?
So thank you, Dominika, for the invite here. I'm glad to be here with you to discuss about such an interesting, however hot topic, I understand. And looking in general, I would say that this topic, it is part of the IT environment for some time now. So B2B contracts are quite, generally absorbed and accepted as being part of the IT industry. And if it is to ask me and my experience, I definitely see it mostly in the CE countries, Central and Eastern Europe, because we are, let's say, with a step behind the rest of the Western Europe in aligning to the general, let's say, EU directive from that perspective. Now to get back to Poland, and my experience in Poland tells me that there are B2B contracts almost in all IT companies. And a rough estimate will also show that probably between 30 to even 50% of the actual B2B contracts are also those ones that need to be reassessed from all the perspectives you just have mentioned, that the legislation is quite clear. It is definitely looking rather from the perspective of substance, less from the perspective of the form, which is the contract. So my estimation, rough estimation, that especially in the professional services companies in IT, those ones that are, in the business model of the body leasing, for instance, are having a higher risk than the rest. Why am I saying that? Because also when you are looking into the IT business models, to the substance, you definitely will find roles and profiles and functions that are the profession functions, like, I don't know, maybe product manager, maybe an architect. Those kind of roles that are definitely independent and value driven in a project, in an maybe full IT product development, then definitely they are more or protected or less risky, I would say. So yeah, to answer to your question, Dominika, I would probably conclude that 50% of the B2B actual contracts in the IT industry needs to really reassess their risk in front of this legislation.
So this is a huge risk, 50%. And Piotr, what is your opinion?
Well, I can only agree with all the points that Joanna mentioned here. I was trying to get some rough estimations as to what are the numbers of the actual potentially touched companies by this phenomenon. And in general, if we look at the market, we have the estimation anywhere between 100 and 250,000 professional services companies with B2B arrangements. In IT sector, it would be around 70,000 companies. And I can also agree with Joanna in the fact that half of that, which is around 30 up to 30,000 companies, can potentially be affected by this phenomenon. One thing that both Joanna and you were mentioning, and it was, I think, interesting, we are talking and looking at the point from the big organization perspective. So when you said there is employees still wanting to keep the B2B arrangement, that's a question of how the control mechanism and in the market will be working, because if the market affected 100% everybody, then this opportunity for other options for a person wanting to continue on the B2B will be gone anyway, like it happens in Germany, for example. There are very tight control mechanisms there. If the Polish government will be going more like after the money from the statistical point of view, they will be looking at the mid-size and maybe bigger organizations, leaving the small companies in peace because they don't have the capacity. I can also give you some statistics as to how many inspectors PIP has and how are they going to be checking all those companies, but that's maybe later. So then this risk will materialize that you mentioned in your presentation, that people will be going to smaller companies on the B2B.
I saw an article and the inspectorate, they told that for IT sector, this is not in the interest of this inspectorate, IT sector, because they will focus primarily on the couriers, workers, construction workers, etc. Yeah, so
I cannot agree with this, and I'm working with an ex-PIP inspector. She is now also the university lecturer and consultant in that regard, not from the legal point of view, but from the very practical, how the control looks like and so on. She has many friends in different inspectorates across Poland. So let me give you those statistics. We have 1,500 inspectors in Poland. 500 of them are basically based all the time in the biggest Polish companies like Polish Post or Orlen or Żabka and so on, because there are always some complaints from the employees and they need to be running controls on the constant and regular basis. The other 1,000 divides themselves into two. One group is all about safety and security regulations and standards. So they will not be looking at the contracts, but they look at how people are dressed and is the building site safe and so on and so on. They are more physical work inspectors. And then we are left with 500 inspectors versus about 80,000 companies to be touched. Yes, so the scale is tremendous. What we know by now is that the regional so-called wojewódzkie urzędy pracy, regional inspectorates of work, they have much bigger infrastructure and they are initiating the controls. It is already happening, even though the law is still not in place, because it will only go into place on the 8th of July. And they are initiating the controls, gathering the documents on the very bright cases to be then forwarded to the PIP and continued after the beginning of July. That's how it looks. And IT sector will be touched because people make good salaries there, so there is some money to share between the parties.
Yeah,
that's
yeah,
how
financial aspects matters.
Yes.
Yeah.
Yes.
Yeah. Okay. So we discussed about the scale of the risk of reclassification, but do you see any positive aspects of this trend? For example, in employment stability or some corporate governance?
If I may ask first, Piotr, just to share my opinion here. I think if you are looking like, an employee, so from an employee perspective, if it is to choose, I would rather choose to be under an employment contract. Why? Because definitely you have more security under an employment contract as an employee. You make sure that your pension is paid, your social securities, everything is covered. You are also having the protection from the notice perspective, dismissal perspective. I think everything is covered in that labor framework. However, I also understand the B2B, access to cash, because that's definitely the case for a lot of people that were chosen, to work under a B2B contract rather than an employment contract. So the positive aspect is definitely security and protection for employees on one side of the story, and on the other side of the story, if I'm looking to the companies, definitely is governance. It's about the fact that when you are looking in an organigram, you want to see a clean one. You want to see who are your managers, who are your project managers, what role and functions they are covering. And it's also about transparency in the end, because if we are doing a statistics, as Piotr mentioned many times, that statistics is important for us as managers to have an opinion, but even more important in the decision making. The transparency of the reporting really helps in this case, because exactly what your quartile in your payroll is per a certain function, per a certain job description, per a certain seniority. So all these kind of aspects, I see them more from the positive side of the story rather than as risks, if it is to add my 2 cents to the question.
I can only agree with this, and Surprisingly, I was observing this situation developing mid last year until the end of the last year, and I saw that many consulting companies were selling on fear. So they would be saying, oh, PIP will come and they will reclassify, and you will have a lot of problems and financial consequences. When I spoke to my clients, and they are mid-size, sometimes even bigger organizations, say 1,000 people to 3,000 people, IT companies, I often focus on the aspects that Joanna mentioned. So in many organizations, you don't have even one onboarding procedure. This system will now require you to have two different onboarding procedures, one for the contractor and the other one for the employee. It's an opportunity for the company to professionalize themselves, to have a better onboarding of the employee. And this is just one of many examples where going through this exercise and going through the checklist and seeing how you give commands or require services from your people, how you run your sprints in the project management meetings. It is a great opportunity for many organizations to professionalize themselves, and then also go into the area that Joanna mentioned. So be more transparent when it comes to the actual numbers, how many FTEs you have, what is the capacity utilization, and so on.
Mm-hmm. So more transparency and one procedure for everybody, I mean for all employees, regardless of the contract, the name of the contract. So these are these positive aspects of this reclassification. And I agree that for many people, they choose B2B contracts because of financial matters, yeah, because they gain more. And the risk is on the company side, not on their side regarding this reclassification. I mentioned about this because 1 month ago I participated in tax hearings, not regarding reclassification, but other aspects, and this was tax procedure for IT company, and some employees and some B2B contractors were heard. And to be honest, because of some questions of tax officer, I see that in such type of contracts, there is no possibility that there will not be reclassified, because it's, for me, it's strict employment agreement. Yeah. So yeah, we will see.
Yes,
about
and
the
that is
yes, Piotr?
that is actually risky. Yes, that is actually risky, because you mentioned rightly that there was a lot of discussion in the public media that PIP will not be able to grab the past social security contributions. That's true. However, PIP is working closely with the Social Security Office, ZUS, and they are exchanging information, and ZUS does have the ability, as well as the tax office, like you said right now, to grab for the contributions also back into 3 years up to 5 years, basically.
Exactly.
Yes. So this risk is relevant.
Yes, there is still a risk. Yeah. Do you think this could increase labor costs translate into higher services prices for IT companies?
Oh, yes. I think, in the end, my financial background really triggers me to answer to this question. But, you will have a higher cost anyhow. So how much higher? Probably, again, it's somewhere between 20 to 40% if I'm looking, to benefits, fully benefits packages that the IT companies are really throwing away sometimes these days. So it's a cost increase overall, and that cost increase needs to be absorbed somehow and somewhere. And there are just two possibilities, from my humble financial knowledge. One of the possibilities going directly into the revenue streams. That means that you will need to pay, pass it to your customers, by increasing your prices with pricing strategies, with, I don't know, hourly rates, daily rates that will be higher with that amount. And definitely there will be also a possibility that your customers are not able to absorb that price increase. And that means it will have to be absorbed in your margins. That means your EBITDA will drop with the amount that we are discussing here. My experience says that in these situations, probably is going to be a hybrid model. That means a part will go to the customers, a part will be also taken as a, risk and a responsibility by the company's margin. But definitely the full loaded cost needs to be managed in the end. And that's definitely one of the direct consequences of such a transition, of such a shift to a new business model, in fact.
Yeah. And Piotr, what is your opinion on that?
It's various, because if you look at the smaller size of the market, mid-size companies, say 300, 500, 1,000 people, I have seen and I have worked with a couple of companies who have secured their position, and I can really easily say this now because they are after the first controls and nothing has changed. They have obviously lessened a little bit the rigorous contractual obligations. They have taken away the non-compete that you were mentioning and many other changes, and the impact was zero. On the other hand, agreeing with Joanna, if you look at the big scale of the market, there will be companies who will go the route of converting the contracts into the labor contracts, and therefore the whole market, like the labor price will be increasing, or the cost of service of the IT service, professional services will be to some extent increasing in the market. Yeah, and not everybody can afford themselves, paradoxically, to work with the smaller companies, because big organizations, big clients, they need sustainability of the operations, they need 24/7 service and so on, and that will be reflected to a certain extent in the overall IT cost in this part of the world, because it's not only Poland. Yeah, Central Eastern Europe was famous for this flexible arrangements.
Okay, so this reclassification or this increased labor costs means higher service prices.
It might mean, yes.
Okay. And we discussed about Poland, but how do other countries address this issue of self-employment? Jana, you mentioned it before about Romania.
Yes, I have mentioned before about Romania because I have in my direct management Romania as a country. I worked with Nordic, Sweden, Finland. I worked with Netherlands, so I do have, more concrete experience with these countries. But I would like to focus on Romania because I definitely find it more similar with Poland in terms of, rhythm, in terms of how authorities react in such situations, and how, maybe it's a too harsh word, aggressive they can be, because that's not the same in the Western Europe. But in Romania, the legislation has been changed for a couple of years now already, and there is a very clear difference between what independent B2B means versus a dependent B2B means. And a dependent, it also classifies you directly as an employee. And there are, 7 criteria. If you fail more than 5, then definitely you will be, named as classification as an employee. Yes. And now let's spend a bit of time sharing with you the fact that I've been part in an IT company. I've been part from an IT company that actually, had a control in that sense. And it's not really an easy situation because as you have mentioned, Dominika, there is the labor inspectorate, but there is also the fiscal administration that they will collaborate and work together. They will definitely look for retroactive. I don't know how many years, but in principle, I think, Piotr, you mentioned between 3 to 5, but that's the standard in big lines. So when we are discussing about, the financial impact of such a risk is tremendous. It really can put a company of, as you mentioned, Piotr, mid-size, 100 employees to 200 employees, put in insolvency due to this kind of risks. So it is a serious topic. It is a serious that I would like to draw attention of and to also create awareness around this risk. The managers that are, in the driving seats of such situations, because we need to be aware that that can translate into a business risk higher than we expect. And there were fiscal controls in Romania. There are fiscal controls in Romania regarding this topic. I've seen it in the last years, very intensive, but I also see that IT companies transitioned slowly from a higher risk to a medium risk to almost a zero risk nowadays.
Okay, so almost no
So, yeah.
B2B contractors, dependent contractors exist on the Romanian market at this moment. So
that's not the correct conclusion. I would not conclude that. I would rather conclude that it depends very much on the risk appetite you have as a leader when you have to manage these kind of risks. So if you have a higher risk appetite, then probably you did nothing or you do nothing with it. If you are definitely part of an international larger organization that does not have risk appetite for such risks, then probably you are on the zero side or less than 10% risk side. Yeah, that would be my conclusion.
Okay. Piotr, and your experience on
foreign market? My observation comes mostly from the so-called DACH market, so Germany, Austria, Switzerland, also Scandinavia to some extent, and UK. And I would say that UK is pretty lenient, and there is certain amount of flexibility. They have the law that is called IR 35, which basically checks if the contractor did not have the company and how they perform the services to the company. Are they independent or not? And basically speaking, in all of those countries, there are some kind of criteria. They usually tend to oscillate around the supervision, control, the way you contract the contractor, external contractor, and the flexibility and freedom they have in terms of selling their services outside of the usual arrangement. Germany is very strict. It's pretty difficult to and not very common to have the one-man companies and to invoice. When it comes to Austria and Switzerland, they are much more not so strict, and people who have the aspiration of having 2 or 3 clients, the fractional jobs, doing the fractional jobs, they go for it. In Scandinavia, it is really very company size dependent. So big companies like Rockwool or Danfoss, they will never have contractual situation with their employees or partners. The smaller companies, they do like it, and this is a way of growing the entrepreneurship in the population. If people are setting their own companies, paying attention to their taxes and revenues and so on. So there is some level of flexibility there. you just need to be proper and correct from the legal and operational point of view. That's my experience.
Yeah, I remember one client 6 or 8 years ago from UK. He ran Polish company, and I asked him why you employ people only under employment contracts, non-B2B contracts, because it was fintech. And he told me, yeah, you know, in UK we had similar situation, and it occurred that many B2B contracts were reclassified. Many companies had big financial problems, and he mentioned that probably the same will be in Poland. So he would like to avoid any risk. Yeah. So regarding UK. Okay, so could the potential reclassification weaken the competitiveness of the Polish IT talent market compared to other countries? What do you think?
I really like the topic, Dominika. I really like the topic because, you know, I am struggling myself if this is a topic that it is part of the competitiveness, you know, when it is about IT, quality, value added, value driver, etc. And why am I struggling? Because this is just the cost that we are discussing. We are discussing right now about the cost impact that this situation might occur in our business models in IT. However, and I would like to highlight the however, when we discuss about the value driver in IT or the value drivers in general, what are we looking at? So we are looking for, you know, talents. We are looking for people that can actually contribute to our organizations and move them forward, think with us, redesign them, innovate. And from that perspective, I found in Poland a great talent pool of people. And if I hear the real stories, this talent pool is built up from the first day of education till the graduation of a technical school, polytechnical school, whatever school it is, you know, that has the profile to create these IT talents. So if it is to think about that, I don't think that Poland will be hit in the competitive advantage because it will stay in the proximity of Western Europe. It will have the same time zone. It will be with those enormous talented people from IT. And I think on top of that, I see also that everyone is speaking English. That cannot be really cut it off, you know, from the environment that was already built and created in Poland. So yeah, the cost now, to get back to this topic, even if, you know, if you are looking right now to the actual cost per developer in Poland, and you will increase it, let's say, with 30-40% because of this, it still will be a difference on the cost comparing with the Western Europe in the same range. So even the cost still stays competitive. I would not worry that much from the competitiveness perspective of Poland. That would be my conclusion. Yeah.
Same thing here. I also believe in the concept of selling value, and that is great potential or opportunity for our IT folks to continue developing, because that's where we sometimes struggle, not in the technical space, but on the space of creating and understanding and then transferring and communicating the value add to the client. Long gone are the times that we were competing purely on the cost with countries from the Asian markets, and then we will never be able to really properly compete also for the scale of the population. So if we see this as the opportunity to put more focus on the value, then the cost will be let's say, acceptable, the increase of the cost.
Yeah, and maybe the last question from my side, what concrete steps should business take today to mitigate the risk of reclassification?
That's really a very tough question, and I think Piotr, you also mentioned that it is a challenging question in general when we are discussing about what you can do different that you have done today in order to mitigate these risks. My, experience, I will just have to focus on that one, and I do not want to give advices or, to teach others what to do. However, what we have done as leaders when we had this kind of risks on the table and we need to manage them was to start by putting this topic on the agenda of the leadership team. So that was one of the first steps that we have done, meaning that we created awareness about the existing of this risk. If you do not, consider this as a risk and you put it aside, it doesn't mean it doesn't exist. It doesn't mean it's not there. It is what's happening. It's still increasing while we are speaking. And it can create, a really something very damaging for your company if you are not becoming conscious about it. So that was the first thing we have done. Secondly, we made like an inventory to, really understand with our own lens the magnitude of the risk. Is it 10%? Is it 60%? How much is this risk for our company? Because we also need to understand. And what I will probably a small advice I will give here, if you consider yourself that the risk is 60%, add 10 more, because for sure the fiscal authorities and the labor inspectors will consider it even higher than you think. It's always like that. So yeah, and after that, we also said from now on, we are not going to hire any B2B that are risky. We are not going to continue to develop this risk, but rather to start managing the risk. And yeah, we were looking into the contracts, to the form part, but that really doesn't really help a lot. You really have to look to the substance and start really managing your risk, step by step, and transition to a less risky to non-risky situation. So that is, in big lines what I have done. I cannot really have better ideas on that. Maybe Piotr, you can help me and build up something here.
I will be happy to do so, although I really like your point that you don't want maybe to advise somebody what to do. That's a pretty wise statement. What I can share is my experience from that situation and the experience with a couple of clients. The experience is that first of all, you need to clean, if you have done those first two steps that Joanna mentioned, and you say, okay, that is a risk, we need to mitigate it somehow, and we need to address it. So first thing you want to do is to clean up the house, because you will often see that you have contracts that are 7 years old, for example, or 12, and nobody was looking into them for the last 7 or 12 years. And there is another changes in the labor law in the meantime that happened, and you shouldn't be actually putting this kind of wording. So you will not be able to start efficiently without the lawyer, but this is only phase 0 of cleaning up the house. Then you need to look at the business model. If you are a hourly company or managed projects company, if you work more on time and material or on the fixed costs, combine it with the way you treat your business-wise, you treat your contractors, see if there is any consistency in this. You can also check if the contractors have the flexibility to provide their services elsewhere. And, there is a number of topics that and this is a difficulty in the situation, that there is no silver bullet for all the companies to address this issue. Some companies, when they are more focused on the outsourcing services, they will have different setup, business-wise, finance-wise, and also working time-wise, versus the other ones who are, for example, providing specific projects or services. So you need to be a little bit flexible and a little bit dancey in order to build your argumentation for the potential control situation. And then you can consult somebody who has done those controls in the past, because it makes a lot of sense for the newcomers, so to say, into the games. I've had many IT companies who have never had this kind of control, so they don't know what is the difference between wysłuchanie and przesłuchanie, which is like hearing versus simple testifying on the situation. They don't know what they should or can be sharing with the inspectors, and what is, for example, under the law of personal data security, RODO or GDPR. So then you need some help to get prepared for this situation, because sooner or later it might come. And then you see, you look at the whole cost and risk, evaluate this, and then you can take those decisions that Joanna mentioned. So, for example, you can only use B2B contracts to professions who are inclined more into the B2B. That was really nice, really clever statement that you mentioned, and maybe not focus on the regular roles that will be under the risk. Or you don't have 10 Java developers on B2B and 10 on the employment contract, because the question why will pop up immediately, right?
Yes. Yeah.
These are just a couple of practical tips. Every company is a little bit different, or many of them differ by the approach to their market situation, and you combine a lot of different puzzles once you have cleaned up the house in terms of legal compliance and the contracts, and also the working time measurements, and many others. I mentioned also the onboarding procedures and so on and so on. There is a whole checklist for that.
Okay, so to verify, check, assess the risk, and implement some remedies. Yeah.
Yes.
Okay. Joanna, Piotr, thank you very much for your input and interesting discussion, your views on this reclassification. I'm not sure if anybody have any questions to our panelists.
Thank you.
Thank you.
Yes. We are about to finish, but I need to say that, Dominika, this webinar was a blast. Thank you for hosting such amazing questions and running such a great discussion. Piotr, Joanna, your insightful answers, your practical approach makes this webinar really, really practical for those who are in front of such a situation that they need to do something. So I hope that everyone who is in such a situation, and I believe that there is a lot of companies, will listen to you and will find this content useful, because it is not so common to listen to such information. Dominika, do you have one sentence, one thing that surprised you during today's webinar?
It's 50% of risk. Because I see that's a high risk, to be honest. Yeah.
Is it half full or half empty from your perspective, Dominika? Full.
For the auditors, if they if they hear 50%, okay.
Yeah.
That's a lot. So what we can do, Dominika? What we can do right now?
So I if I can recommend anybody, because Joanna told, that only can share her opinion and her experience. I think that every company should look into their employment contract, employment structure, and to think about the risk and assess this risk. Because, as Piotr said, somebody are open for the risk. And for them, I think they will accept it, yeah. But for some companies, for bigger companies, maybe this risk will not be acceptable because of the level of this risk also.
Yeah, that's quite a bet. So we need to finish. So Dominika, once again, thank you for being our partner today, for having such a great guests, and of course your presentation. Joanna, Piotr, thank you really so much. Thank you so much for your insights, for your private and private observations. And in 3 weeks, we are going to have a webinar hosted by Małgorzata Gryz. And this will be a surprise, but I believe you will like it. So thank you once again.
Okay.
Thank you
very much. It's been a
Thank
pleasure.
you for the invite. It's been a pleasure. Thank you.
Goodbye.